This is over 4 days now since the Presidential Election Petition court affirmed Bola Tinubu as the winner of the presidential election conducted earlier in the year, and yet the atmosphere still remains charged with political tensions. Opposition parties known for their unwavering spirit are now fervently rejecting the court's decision. Recall that the 5-member panel, in a final judgment read by the head of the panel, Justice Haruna Simon Tsammani, struck out the 3 petitions filed by the People's Democratic Party, the Labour Party, and the Allied People's Movement. And now the opposition parties are asking the court to invalidate the February election, while claiming that the justices manipulated the law to subvert the will of the people. Despite that the court's judgment being final and legally binding, the opposition's decision raises significant questions about the future of democracy in Nigeria, especially as to the issue of will it stand, spark an era of electoral reform, or further deepen a political rift. All right, and that's what we will be discussing now. We have joining us in the studio lawyer and former Ogo West senatorial candidate, Femi Aino. It's good to have you join us.
Yes, thank you for having me. Yes, thank you for all the time. Yeah, thank you.
We also have joining us from our Abuja studio, a senior advocate of Nigeria, Adamson Adeboro. Leonard Silk, good morning, and thank you for joining us on TVC Breakfast.
Good morning.
Let's start off with you, Mr. Adeboro, SAN. Talking about the controversies that the judgment, addressed, and how well it settles, or to what extent it settles, the key issues that formed the 3 petitions. What do you make of it? The dust is yet to settle, especially now that the major opposition parties have said they will go on to appeal. But, from an observer angle, and we assure you, you followed, the more than 12-hour judgment. What do you have to say about, the reactions from lawyers and even non-lawyers to that judgment?
Well, the Presidential Election Petition Tribunal has done a wonderful job. And as the judgments have deepened our democracy. The comment of people, as far as I'm concerned, everybody is entitled to his opinion. But the issue is this: the judgments have come to stay. Because the judgments were so deep and touched on virtually all the areas that agitated the minds of the people. However, the justices of the tribunal are human. So the judgment cannot be perfect. However, if the judgment is not perfect, the parties have the constitutional right to ventilate their grievances into the serenity of the Supreme Court, which I am of the opinion that a lot, about if not all of them, have started the process. So, if that is the case, all we need to do is, having submitted to the decision of the court, is to be patient until and except and unless the Supreme Court has given a verdict one way or the other. So whatever the opinions of people might be, as far as I'm concerned, the judgments have come to stay, except the Supreme Court set them aside. Those judgments, to my mind, are fantastic. They are good judgments. Because the 3 judgments have settled virtually all the issues that we have been debating in the electoral atmosphere, as per the issue of the electoral jurisprudence. So as far as this matter is concerned, the victory of President Tinubu has been settled. And the president today should settle down to address the issues, the problems that are confronting Nigerians.
Right, Leonard C., I would like to do a follow-up on what you said as regards the fact that the judgments are very interesting, looking at what your description of the judgment. But then you said that the judges are not perfect. So is that to say that there were some, maybe some things that you noticed in the delivering of their judgment? Because some critics had said the judges sound as though they were speaking for the APC and INEC, and they were taking sides. Is that the point you're trying to make, or could you clarify on what you meant by that?
What I meant is clear. We are all human beings, including the judges. So if there are errors, one or two errors in the judgment, it's understandable. But the question is, if there are errors, are they substantial enough to upturn the judgments on appeal? To my mind, I would say no. For instance, the issue of the FCT, I think that is clear. FCT does not have the status of a super state to warrant the court saying that except you have 25% in FCT, you cannot be declared if you have made the constitutional requirements in other states. So that cannot be, that's not wavering. That cannot be touched. Then on the issue of proof, the petitioners have approached the tribunal to say, there were election malpractices or non-compliance with the provision of the Electoral Act. The body is on them to prove so. So if they have not proved, based on the evidence before the tribunal, then the tribunal was right to hold so. Now, on the issue of who had the majority of of the votes lawfully cast, again, if the petitioner were alleging that, the President Tinubu did not have it, they had the body to prove how they should be preferred to President Tinubu. Did they have the highest vote cast in the election? If they did not have, then the election was right. Now, the other area I'm thinking about is this. On the issue of point of law, for instance, on the issue of transmission to IRF, or whether whether INEC can rely on their manual, while conducting the election. Now, in that area, the Supreme Court has said that the manual of INEC form part of the law. So if INEC has violated their own manual, if the provision as to transmission of election results to IRF was not followed by INEC, which provision was contained in their manual, now the issue has to be resolved at the Supreme Court. Whether that will be the non-transmission of election petition from the polling unit to IRF will constitute a substantial breach of the provision of the Electoral Act or the manual, because it is not contained in the Electoral Act. And if that will be enough to set aside the judgment of the tribunal, that is left for the Supreme Court to decide. So that's why I said that there will be one or two areas where, great areas, where you need to resolve at the Supreme Court.
All right, let's put you on hold and compare your analysis so far of Wednesday's judgment with that of Mr. Femi Aino here with us, also a legal practitioner, and you obviously followed the judgment, the happenings before and after, and among the plethora of views that have fallen out from the judgment is the issue of reforms, as in if we can get more positives or get make headway from now and move on somehow in terms of what place INEC should have when defending or in electoral petitions, election petitions in the future. So far, INEC remains a defendant, but lawyers too have said INEC should not be an interested party, or whether INEC should even be the one in the spotlight in terms of proving that its elections were done fairly. And then the issue of the role the Court of Appeal played, people say, is it not worrying, or should we not be worried that amidst the flaws of INEC, the Court of Appeal ratified INEC's conduct at the polls?
Yes, that's why I agree with the Lana Council. If you look at the judgment, the dust is not settled yet. And the president is not yet out of the wood, because don't forget, there's still a right of appeal. But this judgment, you see, if you read the whole judgment, first of all, there are some disturbing aspects about this. Number one, this is a judgment that was read for almost 12 hours, if I can recall. And also at the same time, the judgment ran to about 798 to 800 pages. That's 768. That's very disturbing. What are we litigating about? Just whether somebody was validly elected as the president of Nigeria. We are not litigating whether Nigeria should not even be a country. And there's something, you see, the world is moving on, and Nigeria seems to be falling behind. Number one, it is possible for all the justices come up with the summary of that judgment, read the summary on live television, and then a minute after, upload the judgment. Anybody who wants that judgment, you can go on their website and you download, okay? Because you will still recall what happened in the UK when Boris Johnson was the prime minister as to whether parliament should be recalled or not. That was litigated in the Supreme Court over 2 days. And the third day, they gave a summary. Within a minute, you can go to their website. So we need to embrace that, because people sitting down for 12 hours reading a judgment, and the lawyers are sitting down there. Well, I don't know how they managed to cope. But anyway. Sorry?
Some slept.
Well, who wouldn't? Yeah. Who wouldn't? Yes, if you sit down. That is very sedentary lifestyle. But that's a side issue. But going to the main issue is this. Number one, where should the spotlight lies? Is it on INEC or the presidential candidates? And that is the issue. INEC is the empire. So there is no way whereby you challenge the election, they will not have a role to play. And now, what the burden? Who has the burden of proof? The burden is on the petitioners to say that INEC did not substantially comply with the Electoral Act. Then INEC has the burden to say we comply with the Electoral Act. Now, another thing, and I think the Lana Council mentioned it, which we all need to be concerned about. This issue about manual or guidelines, that is the issue where I have issue with the tribunal. The issue of Abuja, 25%, I agree with them to an extent. But this issue about guideline, you see, in public law, and I'm glad the Lana Council is there, there is something you call the concept of legitimate expectation. If you are applying to a university to enroll, and the university has a guideline that the enrollment, this is how it's going to take place. One, you arrive by 9 o'clock, they will take your picture. After taking your picture, they do your fingerprint, then you go to student. That is the guideline. Now, you have a legitimate expectation as a prospective student that the university will follow that guideline when enrolling you as a student. If they fail to do that, you can challenge it in the sense that they breach your legitimate expectation and you suffer a prejudice. The prejudice is because you were not enrolled, because of their failure to follow the guideline. And this was not ventilated before the tribunal. That you say, what is the essence of having a guideline if you are not going to follow it? And what this justice said in the judgment is that, look, INEC has the discretion to decide how they're going to transmit the result. But they have a guideline as to how they are going to transmit the result. That is one issue. The other issue, which the Supreme Court will have to decide one way or the other, is about this forfeiture that happened. I agree with what they are saying, that it was a civil forfeiture. That's fine. And it is not a criminal matter. That is understandable. Then another point, which is a sub-point to their main decision, was that even if the president was convicted of a criminal offense, it has to be 10 years. It has to be 10 years before the election. And this is a matter that happens decades ago. Well, that is one side of the argument. But there is another side of the argument which the tribunal failed to engage with, or which was not canvassed before them. What is the common law position regarding this? Forget about 10 years. Forget about whether it is criminal or civil. But the point is that we are having a man who is going to be in custody of the treasury of the nation. Now, at common law, is it right for such a person to have had a civil forfeiture against him? That is a matter we can argue from now till Christmas. But that point, maybe because it was not ventilated before them, that's why they didn't talk about it. But the good thing, how this will threaten our democracy, they said that the transmission of results, that was not provided for, that INEC can do this in the Electoral Act. Now, that is where the matter will now shift to the Senate to decide whether there's the need.
Okay,
this. Then the Senate will have to deal with that.
And
if the Supreme Court still say the same thing. So, you see, when you look at the whole thing, that judgment, honestly to me, is a bit jumbo. Partly right and partly wrong in certain respect. And there are some issues which were not ventilated. And for the lawyers, I must commend them because, you see, to deal with all these electoral matters within the timeline is not an easy task. But the only mistake which I discover is that, you see, the preparation for this should have started months ago. Don't wait till you get the election result. I know you will need part of that. And also, look, Atiku has been challenging every election till God knows when. Now, you need to go to those judgments, read it, look at why they rule against him, and then you map out your strategy. But if you leave it too late, now, there will be a lot of issues. And another concern which I have before I give way is the case management power of that tribunal. Number one, they said, I think it's in an LP case, where they said some of the evidences brought, they were outside the timeline 21 days. And because of that, all the witnesses,
10 witnesses,
10 witnesses out of 13, all their testimony were ruled out. You see, those sort of matters should have been dealt with earlier on, not wait. Because you see, because when you, after hearing everybody has called the witnesses and you are not admitting their evidence, you see, it doesn't work. What you should have done is to exercise the case management power. And the lawyers too need to take something on board from this. Is you see, when you keep your case very simple, it becomes manageable. Then you can follow the trend. But when you just want to ventilate every point, at the end of the day, this is what you are going to get, 800 pages judgment, and at the end of the day, people get bored. How many people are going to read that? But having said that, they've done a good job, but for those who are aggrieved, there is no point attacking the judges. Go and ventilate your anger at the Supreme Court, and let's see what the Supreme Court does.
So for the avoidance of doubt, it's actually 794 pages, just 6 pages short of 800
but still
pages.
long.
Still
long.
Yeah, exactly. You know, because we got the number wrong. So the thing is, you know, we talked about the issue of the guidelines. You've raised a lot of issues, and I think we need to get to the brass tacks. The issue of the guidelines, the fact that it is not in, it is the guideline, it is not in the Electoral Act, but then everything is subsumed, you know, into the Electoral Act and also the Constitution of the Federal Republic of Nigeria. But if INEC sees that what the guidelines we've issued earlier on is being threatened, as they talked about, they said about the cyber attack or something like that, is it not their prerogative to change this guideline, not changing the goalpost in the middle of the game, but because they want to forestall any unforeseen contingency that might overall affect the outcome of the election? Are they not, you know, don't they have the power to do so?
No, they do, because don't forget, there's nothing like a perfect system. And there are certain things which you don't envisage that will happen suddenly. But do you have a contingency in place? That is the question. And the question is...
The contingency might be the fact that collation of results is not meant to be done electronically, even though it serves as, you know, transparent means for people to also follow up. But they already stated it that it will be done manually. So I'm not sure why there should be issue around that.
Well, why the issue is that because I think it's the guideline that says it could be done, it has to be done electronically. That's why some people, if you listen to Dino Malai during the collation of result, that was why he was very aggrieved that, look, you have this guideline, you are not following your own guideline, and when you do this thing manually, why do you have the electronic system? It's just to avoid all this corruption, irregularities, manipulations, and all those arguments. And if you have a guideline, you see, the guidelines are not written on a tablet of stone. It is like you having a policy. You see, law can't take care of everything. That is why if you are charged with responsibility, and this issue about guideline is something which I use regularly, that, look, if you have a policy, what is a policy? The policy is a statement of action. Now, the law can say, you are responsible for deporting people who are in the country illegally. But you will come up with a guideline or policy as to how you're going to carry out that. Look, before I deport them, I'm not just going to go to their house, pick them. I need to find out their circumstances. That is your guideline. I need to interview them. I need to find out whether they have a medical issues or what have you. So if you now wake up in the morning, then you go to their house, you pick them, take them to the airport to be deported. Somebody is going to argue that, no, you are not even following your own guideline because you did not even interview them. You did not find out the circumstances. Then the judges are going to ask you, why do you have the guideline? It's not a packet of the cigarette policy, whereby it's just on paper, but you don't follow it. If you don't follow it, the public confidence in your ability to follow procedure is going to be seriously undermined. So what you do, policy decision makers, INEC, administrative officer, they review their policy and guidelines as time goes by. That, look, do we have an issue here? And that is the problem here. That, look, people have expectation that INEC will follow their guideline. And because they didn't follow the guideline, they suffer a prejudice because the election there were a lot of irregularity about the transmission of results. But the judges didn't look at that concept of legitimate expectation that did they follow, the guideline might not be the law, we agree. But why is it there? It's just to bring the law out and implement the provisions of the law. That's why you have policy. That's why you have guidelines. But you don't have it on paper alone. You must follow it. And at the same time, you see, the other problem about this case, if you look at everything in the round, is that you discover that some of the lawyers, too, maybe because they are under pressure, there are certain things, they are very minute, but they are very vital. That, okay, look at this Chicago issue we are talking about here. That matter is going to be heard in the U.S. tomorrow. What difference is going to make? I don't know. Even if they said it was a fake certificate, are you still going to go to the tribunal, or are you going to use it at the court, at the Supreme Court?
Is that even likely?
Well, that is an issue. Is it admissible? You see, if there has been a conviction and you want to bring the evidence here, you need to bring the certificate of conviction. And then who is going to produce that document? The judges, they said, look, it has to be produced by a police officer. So these are all the necessary issues. So the president is not out of the wood yet. Let's see what the Supreme Court will have to say.
Let's bring in Mr. Adebor Lenesiok into the conversation now. And, you know, I want to take you up on what Mr. Aino said here, talking about the expectations of many Nigerians regarding to INEC's assertions before the elections that it would utilize its IREV platform for the instant upload of results and other related areas there. You know, the fact that INEC didn't do that, you know, on the real-time instant as promised. And then there is the feeling of disappointments that INEC failed them, and the court went on to affirm INEC's move, or, you know, non-action, so to speak. What possible reforms do you expect to happen, you know, in future elections as a fallout of this landmark decision?
Thank you. The first question you ask yourself is whether a promise is a law. or the promise can be at variance with the provision of the Electoral Act. Now, if you consider the provision of the Electoral Act, it clearly gives INEC discretionary power on the method to adopt in transmitting the result from the polling unit. So it is not mandatory. They can adopt any system they like. Now, if INEC had gone ahead before the election to promise Nigerians that, oh, we are going to transmit electoral results from the polling units to IRF, and they did not do that, what's the penalty? Is there any penalty provided for under our laws? And the answer here is none. So you can't hold them under any law to say, oh, the penalty of the action is so and so. Now, the Electoral Act is clear about what to do. What is important is the beavers, which is to accredit the voters. Now, all the parties have their agent at the polling units. Then what is the responsibility of the agent? If you are going for election, your agents are armed with the results at the polling unit. Why can't you utilize that? The counterfeit copies of the results given to the agent are more potent than anything you want to talk about here. So if you are going to election petition, Tribunal, to challenge the results at the polling unit, your agents are vital witnesses to use. But here, what we saw is that even none of the agents was called by any of the parties to testify as to what transpired at the polling units. And you are expecting the Tribunal to manufacture or to go fishing or to go to the streets like the court held to go and help you gather evidence. That's a great lacuna on the part of the council. Now, when you are going to before the election, but before they went to tribunal, before the filing of the petition, they knew what were aiming at. Perhaps it was just, maybe that area of their petition was just to a mere charade or a mere, just put there to cover up. The actual ground of their petition was the issue of disqualification. That the President Tinubu was not qualified. Now, even that, when you look at the allegation of the forfeiture in the United States of America, it was not a criminal matter. It was a civil matter. Like others have been saying, even if it's a criminal matter, it will land with this after 10 years. So why are you relying on that kind of a thing to say you want to set aside or to upturn or to cancel election? So that cannot work. Now, I've equally listened to other people and say, oh, why did it take the justice of the tribunal that long to read the judgment? Now, what you consider is what led to that. We all Nigerians will read in the social media how all eyes are on the judiciary. Now, if there is anything, if the court, if the tribunal has not pronounced on all the areas, on all the issues brought before the tribunal, and they have breached their judgment, people will still have been complaining by today that, oh, a lot of things were hidden. That was why they did not pronounce on all the areas brought before the tribunal. So, whichever way you look at it, the tribunal, as far as I'm concerned, was correct. It read the full judgment before. It was painful, but we just have to take it because of what led to that.
Let me stay with you on this. In that sense, stakeholders, some actually absolved the judges. They blamed. They said that we should move the blame to the National Assembly, the Ninth Assembly, for Atiku Obi's laws, as the leadership newspaper actually reported that the Electoral Act that was drafted, provided escape route for manipulators and all of that. So do you feel that the judges have done a good job using the Electoral Act, the one that we have, that the National Assembly didn't tidy up all of these loose ends in order to ensure that we have, free and fair elections, as some have been saying?
It is the issue of the forfeiture. As far as I'm concerned, it's in the realm of, particularly reference for this matter, it's in the realm of civil law. So the law is perfect. There's nothing wrong with our law. The Electoral Act, the 2022 Electoral Act, is a good law. Provides for all the things you need to prove as a petitioner. So if you don't comply, you're on your own. So if the tribunal has given judgment based on the existing law, then it cannot be faulted. It cannot. So the issue of calling for amendment of the 2022 Electoral Act, to me, does not even arise in the first place. The laws we have regarding electoral jurisprudence in Nigeria, they are good laws. All you need to do is to exploit the laws to the letter, and whatever thing, whatever justice you desire will be given unto you if you follow the law to the letter. So the issue of amending.
Sorry to butt in. Some of the things they are calling for is that they should allow for electronic voting, that everything should not be made electronic, rather than resorting to manual aspect of the election process. That's what they are calling for as part of the additions to be made to the Electoral Act. Do you also see it that way?
Yeah, you see, it's a good area, but we have to take these things gradually. Rome, according to the Victorian age, was not built in a day. So what we need to do is to systematically develop our jurisprudence with the courts, which we are doing through the judiciary. They pronounce on great areas that we develop on. Even in the United States, in the United Kingdom, that's how you have the laws. Some of these laws are not even written, but because of the pronouncement of the courts, now it becomes the law. Now, the issue of electoral voting, I agree totally with it, but it's a matter of time. There are still some places in Nigeria where you cannot do that, except we allow electoral voting to go pari passu with manual voting. So if you can do this, then I think we are talking. But otherwise, a lot of people will be differentiated. If you say, oh, let's go solely for electronic voting, to the exclusion of manual voting. So if you allow it to go pari passu, then we are talking.
All right. Let me also serve that as a base for our next question to Mr. Aino in formulating positions that will better the electoral system in Nigeria. But what do you make of the intentions of the legislature in drafting the newly amended Electoral Act, and whether it was deliberate on the part of politicians to get a leeway as to a way to manipulate, come out of allegations that perhaps the law will not strangulate them in their political ambitions, But how do we move on from this point?
No, I won't say that, because the intention of Parliament is to ensure we have a free and fair election. And that's why, we have the Electoral Act. But I disagree with the Learned Counsel with respect when he said the Electoral Act is a good law. But having said that, there's still a lacuna. If you read the judgment, where they said there is no provision for
in the Electoral
Act. So which means it's a document that is not perfect and is subject to amendment. And for the 794 pages or so judgment, you see, I think the mistakes stem from the failure to narrow down the issues first. If you appear before some of these courts, where I've been and where I come from, the first thing the judge sit down and say, first of all, let's identify the issues. And even though you have your grounds of appeal, you have all these particulars and what have you, when you narrow down the issues, it can come down to 5 issues to be decided upon. That saves time, that saves cost. And at the same time, you can get a watertight judgment. But if you leave all the issues to be ventilated, there will be an issue there. That's one. And the second point, the problem with this case is that on the part of those lawyers is that, you see, when you have 176,000 polling booths, polling units, and at the end of the day, you are calling the coalition agents as witnesses. And what they are saying in the judgment is that these are people who rely on hearsay. They were not at the polling unit too. It will have been appropriate to call those polling unit agents, and they will be able to give a first-hand account and be a reliable witness. That's one. And if you look at the result of the election, the difference between President Tinubu election and Atiku is about 1.8. That of Obi is about 2 point something. Now, another criticism is that, look, you failed to tell us what score, what will you get from those states? Assuming the election was even perfect, everything was fair. What is the score? You are likely to close that margin. There was no evidence presented. And that is something that we need to reflect upon for future. But this judgment, what I think should flow from there is that people should have it as a template. When there's going to be another election in the next few years. There are people who are going to contest to be president. They will need to read this judgment and know what.
This year.
Yes, this there's election in other states to know what evidence are we going to, what do we need, because they have this as a template, and that will help as a guide. Now, the other aspect, which is very important, the practice direction too. We need to review it regularly so as to make sure that, you see, the way it is a bit cumbersome. And for those lawyers, you know, I sympathize with them because, you know, going from this place to this place, looking for evidence, INEC too is a defendant, respondent in the case, and they are the people who have the evidence which you are going to use. So, you know, these are issues which we need to try as much as possible to address. But I still look forward to that day, when we will have an election, we will have a president in this country, and every opposition party will agree that is the result of the election.
Just like former President Jonathan.
Exactly, right. And then we just move on.
Right. Let me, because we have limited time, let me go to Alelen Sik in Abuja. Please talk to us about the fact that, you know, Nigerians are reacting, and they said that all of the reactions is to show that our democracy is getting strengthened. But then you see some people lampooning the judges, you see some people throwing invectives on the judges and also the candidates and all of that, and some unprintable names being called on the social media. And we understand that Section 39 of the 1999 Constitution, as amended, you know, allows for freedom of, you know, expression, etc. But then it's been taken away by Section 45 of the Constitution. Talk to us about how people should express their feelings, their disaffection or their dissatisfaction about anything, any decision that has been taken by the court without running foul of the constitutional rights.
Right. Like you have rightly observed, Section 45 of the 1999 Constitution is clear that no right is absolute. You know, and don't forget that where your right ends, the right of another begins. It's unfortunate that we are hearing the barrage of attack on the judges. Our judges are courageous. In fact, I commend the justice of the Presidential Election Petition Tribunal for the great job they've done. Now, you don't win cases on social media. You prepare for your cases and go before the court of law and take materials, vital materials before the court and activate the law. Not all these debates on social media and attack on our judges. Why we're in Nigeria, the same judges we are attacking today were the judges who obtained the election of the former governor of Ondo State, Agagu, and gave it to Governor Mimiko. It only happened in Bayelsa and other states in Nigeria. Then you were praising them. Today, because they've decided the matter based on the fact before them, based on the evidence before them, based on the existing law, the extant law in Nigeria. Now you are castigating, you are intimidating them. And we are forgetting that they are Nigerians like you. They cannot be intimidated. It's very wrong. It's appalling. that these people were in the service of this nation, serving us meritoriously. If you have issue with any of them, yes, there are procedures. There are procedures to get them answered for their conduct, not by attacking them unnecessarily without evidence. We need to move from this stage to a civilized stage where we allow them to do their job. As for me, I commend them. On the issue of INEC, why should INEC be defending election petition? You are questioning the conduct for INEC, and you expect INEC to fold his hand, to rubbish, so that the petitioner will rubbish the job they've done. That does not take away the fact that INEC should be truthful in their presentation, in the defense of what they've done. If you are wrong, admit that you are wrong, so that our system will continue to improve. But
all right,
how be it? INEC has a responsibility to defend whatever they've done. So it is not wrong for them to defend election petitions.
All right, let's get to final submissions from Mr. Enohe, especially on the issue of the respect or the blackmailing of the judiciary. Even the chairman of the body of benches, retired Justice of the Supreme Court, Mary Peter Odili, also was victimized online. In her call that politicians should be mindful and not to bring down the roof of Nigeria because the commotion will splash on everyone.
I agree. I condemn the unwarranted attack on the judges. But on the flip side, if you're a judge, you're supposed to have a thick skin. That is, it comes within the territory. Because you see, it's an adversarial system of justice. You listen to this side, you listen to that side, then you take a decision. The other side that you rule against is not going to be happy with you. Some will storm out of the court. Some will go outside and make series of accusations. And it comes within the territory. Even in UK, I was in court, and the judge refused bail. The mother just stormed out and said, look, this judicial system is this and that. I made a series of derogatory remarks. She went out, then she came back in again and said, sorry, my lord, I'm really, my head is spinning. And the judge said, look, I could understand. So you don't need to make a big issue out of it. And this idea of freedom of expression.
No, but if the idea is to bring the roof down, as she has said, if the idea is to cause chaos and make the country, unrest.
Yes, all of us should condemn that. You understand me? Because at the same time, you need to appreciate when you come to court. Somebody is going to win, somebody is going to lose. Some days you get completely strangled. It comes with it. And people should know that when you come to court, it can go the other way. Even though you may have that expectation that is going to go your way, that is it. But to win an election, challenge in Nigeria, with this electoral act and the text, and that is something which I want the Learner Council to know. You see, the text is very high because they are applying a criminal standard of proof that is beyond reasonable doubt. And what they said in this judgment is that, well, they failed to prove beyond reasonable doubt that INEC did not comply substantially with the electoral. That is a very high test. And for anybody to win that, maybe we should consider the opposite and be using the balance of probability, which is a lower test, in order to move forward. Hopefully that day will come.
All right. Well, you both, Mr. Adamson and Mr. I know you've raised up some interesting points that might just give us the leeway to stretch this interview a little further. But that will be after the break. We'll come back to dissecting the issues that flowed from the Presidential Election Petition judgment last week. Stay with us.
Things in life, making great music is a process. And a key part of that is the right data, and the data that helps you understand what needs to be done and how to do it, and what sound will connect with listeners.
No, bring it up. Let's know everybody sees.
Whatever aspect of life you're into, enjoy the journey. 9 Mobile's got you covered.
Dial *301# now.
9 Mobile.
Because no matter where you go, no matter how we be, I go
always ready for you. Anything where you drop, oh, whatever you drink, oh, I cannot be the bar for you. All I ask in return is that you treat me a little better with eyebrow. Toilet cleaner. My hygiene now your auto. Eyebrow. Toilet cleaner. It's a win-win for me and you, so make me win more.
Discover Lipton's flavorful and balanced taste. We pick fine quality tea leaves from selected tea gardens around the world to give you Lipton Yellow Label's flavorful and balanced taste in every sip.
Thanks a lot for staying with us on TVC Breakfast. We have been looking at the issues which are yet to abate, by the way, since the Court of Appeal affirmed the electoral victory of Bola Tinubu at the presidential election last week. The main political parties who had petitioned or brought in petitions before them have now said they will appeal. They've obtained copies of certified true copies of the judgment and are heading to the Supreme Court for a final decision on the controversies from the presidential election. We have been speaking in the past 30 minutes or thereabout with Adamson Adeboro, Senior Advocate of Nigeria, joining in from Abuja, our Abuja studios. And here in the studio with us has been Femi Aino, a lawyer. Both of them lawyers. Leonard, so back to you. And, during the break, we were also looking at specific wordings that one particular word or phrase stood out in the judgment last week. And it was the issue of the issue of beyond reasonable doubt. Of course, this phrase is usually used to prove a case in a criminal trial. But we saw the justices also talking about the level of evidence, how well the evidence was proved beyond reasonable doubt or otherwise, especially as to the conduct of the elections on the part of INEC. And, Mr. Aino was wondering as to the place of proving beyond reasonable doubt, the need for parties to prove beyond reasonable doubt in an electoral petition as this. Please respond.
Yeah, what the law provides for is allegation of crime in election matter must be proved beyond reasonable doubt and is applicable in criminal law. When you allege crime in election petition, you have taken your matter from the realm of civil matter to the realm of criminal matter. To that extent, is the requirement, the required proof is proof beyond reasonable doubt. But for other ones that are not in the realm of crime, then it is proof on preponderance of evidence. So don't get it mixed up. It is when there's an allegation of crime. For instance, the issue of forgery, the issue of thuggery, manipulation, and all sorts of things, they are in the realm of crime. So, if you are to prove that, it is proof beyond reasonable doubt. Now, all other issues, like somebody is not qualified, does not meet the requirement of the Constitution to become a president or governor or whatever. Those are proof on preponderance of evidence. So there are two areas.
So talking about...
Just before that, Ibrahim, I just wanted to get your views, Mr. Aino, on what Mr. Adeboro, SAN, has said on this issue of proof beyond reasonable doubt. And the justices said as much, saying, alleging that Kogi State Governor Yahaya Bello and others, performed or conducted criminal activities. Why didn't you bring Governor Bello as a witness or as a party? Why didn't you join him? What do you make of the submissions by the SAN?
Yes, I think I'm very grateful to the Learner Council because I think it dealt with that issue head on. Because number one, you approve irregularities, manipulation, and other dishonesty. Those are part of the allegation. And what the Learner Council seems to be saying, which I agree with hindsight, is that, look, when you want to prove order, you must be able to apply the criminal standard. And I agree with him absolutely, and I'm very grateful for his line of thought. But having said that, on the preponderance of evidence, to which will be dealt with on other issues, those are issues earlier on the tribunal should have dealt with. And the lawyers too must try as much as possible to engage that what is the probative value we are going to attach to this if we call this person? Will this person be a reliable witness? Will this person will be able to stand up to cross-examination? Those are life issues. The other, and I like the way you raised the issue about the governor of Kogi State, because there was this allegation against him that he engaged in electoral fraud. Well, if ideally the parties who are making that allegation should have taken the steps to call him. And that is what they are saying, that you didn't even join him. I don't know. I didn't agree with the joiner because he didn't contest as a president anyway. But you can still call him as a witness. And then if he come in the witness box and you are able to mesmerize
or compel his attendance,
or compel his attendance by issuing the appropriate summons, then if you are able to mesmerize him in the witness box, that will probably help your case in a way. But, you know, you keep learning as you go along.
Indeed.
All right, our learned counsel in Abuja, let me come to you. You know, the issue of being able to prove, disprove, etc. I love all of the legalese that have been used so far. But the fact that, speak to the tact, the carefulness, and also the brilliancy. I don't want to use the word brilliancy, or let's say how careful the counsels to the opposition parties had been in terms of preparing their allegations and their case in court. Because I had a lot of the petitioners failed to prove that more than 100 times, you know, in the 794 pages of the judgment that was released and read out by the judges themselves. Speak to how carefully they were able to prepare their case, you know, lay these allegations before the court. How much would you say they've done in doing this?
I must confess, the counsel to the petitioners are one of the best brains in this country. They are one of the best election experts in lawyers in Nigeria. So I will not stand here to condemn them. They've done a great job. However, a lawyer can only excel based on the availability of materials at their disposal. So what are the materials available to them at the time of filing the petition? That will determine whether they did a good job or they don't do a good job. I've been hearing all manners of languages being used against them. I disagree totally. They are good lawyers. They've done well. They've done their best. They provided they made available to the tribunal the materials made available to them. So you cannot condemn them. The fact that, they've not done they've not discharged their duties to the expectation of the judges does not take away the fact that they are good lawyers. But you have to look critically into the materials made available to them as at the time of filing. Now, don't forget the fact that election petition is time-bound. If the time has lapsed and materials are now surfacing after the time lapse, those facts go to no issue. They will not be of any assistance to you. So any material you want to use in election petition must be made available within the time allowed by the law. So whatever materials you have thereafter is a waste. The petitioners' counsel made use of the available materials made available to them as at the time of presentation of petition. So you cannot condemn them. They've done well, they are good lawyers, they are fantastic lawyers that you cannot condemn in any form.
Right. So
all right.
Go ahead, Kenny.
We've run out of time now, and there's still so much more on the program. We must thank profusely Femi, I know, here in the studios. Thanks again, and thank you for always being there with us to share in your useful insights. And joining us from Abuja, Senior Advocate of Nigeria, Adamson Adeboro, we thank you very much for your contributions on TVC Breakfast this morning.